the Ombudsman is conducting an investigation does not render her as an adverse witness. In fact, she has merely written the Chief Justice to explain if there is any truth to the allegation that he has $10 million. There has been no adverse finding by the Ombudsman. She is merely performing her mandate and task under the Constitution and the Ombudsman's law. That is not evidence of any adverse interest.
We do not question that there is an investigation, that the investigation is allegedly being conducted by the Honorable Ombudsman, Your Honor, pursuant to law. What we wanted to lay down is the fact that there is already allegedly a finding made by her adverse to that of the Chief Justice. How can she be expected to be neutral, to be unbiased, and to be impartial, Your Honor, in the dealing with the Chief Justice, Your Honor?
The Ombudsman has not said she has made a finding. She merely said that she has gathered or received data. She has not made any finding.
Precisely the gathering of data do not appear to be in consonance with the impartial investigation of a case, Your Honor, because there are complainants in here.
This is to cut short this discussion, unless I am reversed by the impeachment court, given the fact that the Ombudsman, according to the question of the counsel for the defense, has shown some disagreement with the respondent, and the fact that she is the one investigating the respondent by virtue of her office, this court would consider her as a hostile witness and so declare that she is hostile witness, and you may examine her as a hostile witness. Proceed.
Now, being a respondent in your case, his position may be akin to that of an accused in a criminal case.
I said, Your Honor, we're still in the fact-finding investigation. He was a mere respondent. You become an accused only when you are indicted in court.
I'm not saying he is an accused. He may be likened to an accused in a criminal case. There is no similarity whatsoever. Is that your point?
Well, as I said, it's merely fact-finding.
Yeah,
there is no determination yet of probable cause because he has to undergo preliminary investigation. If we wind up our fact-finding investigation and we believe that there ought to be preliminary investigation, then we set the case for preliminary.
Why the necessity of compelling him to submit or to file an answer?
That is what the law says, Your Honor, Section 26.
But this is practically compelling him to be a witness, which is prescribed by the Constitution under Article 3, Section 17.
Are you assailing?
That no person may be compelled to be a witness again. Because the moment she answers, necessarily, she has to state his reason.
Are you assailing the constitutionality of Section 26?
I'm raising it right now because it's a practice. Please.
It does not follow, Your Honor, that if he refuses to answer, then
counsel,
I am still...
Please propound your question. Please. Do not argue with it.
There is a pending question, Your Honor.
Yes, precisely. Ask your question.
My question, Your
Honor.
Whether
leading or direct question, you're now entitled to ask, but do not argue with the witness.
I'm not, Your Honor. I'm asking her, Your Honor, whether the position of the Chief Justice as a respondent or a party being investigated in her office may be compared to that of an accused in a criminal case.
You are asking an opinion.
Yes. Well,
that is a legal characterization.
But
we are dealing with facts here.
But she is very much in a position to answer that.
Well,
Your Honor, with due respect,
may answer if she wishes to answer.
I have already answered, Your Honor.
All right. And in accordance with the Constitution, the law says, under Article 3, Section 17, no person may be compelled to be a witness against himself.
I did not compel him, Your Honor. I said I was just following the mandate of the law. That was his lookout. If he did not like to answer, he could waive answering if he wanted.
Yes,
but again, as I'm saying, Your Honor, you are assailing the constitutionality of Section 26.
I'm showing that that practice is not in accordance with the
It
Constitution,
is
Your
not
Honor,
a practice,
because-
Your Honor. It is a provision of law, Section 26 of the Anti-Graft and Corrupt Practices Act.
Yes, but that,
Oh.
that nullifies the right of... I'm sorry. I'll just ask question. I'm sorry, Your Honor, and I apologize. Now, furthermore, may I direct your attention to this portion of...
Sorry.
your
Let me
letter to the
let me
Chief-
correct my answer. This is not Section 26 of the Ombudsman Act, not the Anti-Graft and Corrupt Practices Act.
Counsel, may I remind you that the time to raise the non-incrimination clause of the Bill of Rights is when a question is addressed to the respondent. She was only asked to appear for
To answer, Your Honor.
To answer, Your
to
Honor,
answer within
72 hours. That's
Then
the...
he can answer that he does not want to give an answer because it might tend to incriminate him. That's the prerogative of the party.
Your Honor, please, with the kind indulgence of the court, Your Honor.
Proceed.
What we are invoking is a right which is fundamental and enshrined under our Constitution, Your Honor. And it is the right of a person not to be compelled to testify against himself. Here, it is our humble submission, if Your Honor please, that the moment he is compelled to answer, he will state all his defenses and everything. And that is practically compelling him to answer. It is a definite violation of that particular law, not merely from being saved from the trouble of incriminating himself, but the right not to be compelled to be witness against himself, Your Honor.
If I may make a counter submission, Your Honor, please. Your Honor, please.
Let the witness answer, please.
All right. Again, I sound like a broken record, Justice Cuevas. Section 26 of the Ombudsman Act requires the Ombudsman to direct the respondent, in the event there's reasonable ground to investigate further, to answer within 72 hours. So I sent that letter requesting him. I want to emphasize the word requesting him. And so the knee-jerk reaction was, oh, the Ombudsman has no jurisdiction over me. That's a phony data and all that. So now you're invoking the Bill of Rights.
I am just stating for the record, Your Honor, the right, the constitutional right of the Chief Justice, Your Honor.
Already answered.
Yes, already. Now, I have examined the various affidavits of the different complainants in this case, and I have not find any statement to the effect that they are leveling an accusation against Chief Justice Corona for the amassing of this $10 million.
If
Do you agree with me?
Objection,
Yes, Your
Your
Honor.
Honor. The question
Yes,
is
sir.
misleading. The witness has never stated that the basis for the $10 million accusation or charge is the 3 complaints. She has never said that. In fact, I do agree with you that if you examine the 3 complaints, there is no mention of the $10 million.
Thank you.
What she said is that the $10 million was gathered from information and evidence she got from AMLA. So the question is
Objection
misleading,
sustained.
Your Honor.
Now, may I go back to the different complaints? Will you kindly tell the Honorable Court whether you have examined any of the complainants in connection with the contents of their complaint?
No, I haven't.
Not even any one of them.
No.
Now, there were statements by these complainants that they have nothing to do with the alleged $10,000.
10 million.
10 million, I'm sorry. I'm not accustomed to million also. Good lang ako sa 10 pesos. No. And they mentioned that they have nothing to do with that.
Yes, Your Honor.
Do you contradict that, or you are not in conformity with them?
That is correct. They did not mention anything about $10
Thank you.
million.
And so far as their complaint is concerned, nothing is touch on the $10 million.
$10 million. No, Your Honor.
Now, this AMLAC that you mentioned a while ago, would you like us to believe that there was already a court proceedings involving the AMLAC?
No, Your Honor, I just asked for assistance if they had any document that had a bearing with the financial transactions and related transactions of the Chief Justice.
But that will require an investigation, isn't it?
An investigation by
the AMLAC. Otherwise, their statement to you in reply to your query may not be accurate and true.
No, I think the AMLAC law requires that if a deposit of 500,000 plus is received by the bank, they are mandated to report to the AMLAC these transactions.
But there is no statement here with respect to the AMLAC in coming in, and that the transaction is one covered by the AMLAC. Am I right?
No,
Misleading, Your Honor. The witness already stated that she requested the AMLAC for assistance.
Well, this is a different question now. I'm just asking him about the assistance. If Your Honor, please. I'm sorry.
Reform the question.
Now, my question to you is, there is nothing on record, nor in the complaints of the complainant here, dealing with that AMLAC intervention.
no, Your Honor, there's none.
There is
Precisely, I asked the assistance of the AMLAC because I wanted to know if there are documents in the possession of the AMLAC that have a bearing on the complaints.
Would you like us to understand then that the AMLAC can just come in upon the request of any...
Counsel, may I read to you the Constitution?
Yes, Your Honor.
Powers of the Ombudsman. Paragraph 5. Request any government agency for assistance and information necessary in the discharge of its responsibilities and to examine, if necessary, pertinent records and documents. So it's a constitutional law. The supreme law of the land gives that power to the Ombudsman. And we are wasting our time on this particular point.
No, my point, Your Honor, is notwithstanding the grant of the powers, that power must be exercised in accordance with the procedure laid down by law. I am conversant, Your Honor. I hope the court pardons me.
Please, go ahead.
Oh.
No, I'm not shackling you to articulate your position, but I'm just reminding you of the constitutional mandate given to the Ombudsman.
That insofar, may I proceed now,
Yes,
Your Honor?
please proceed.
That insofar as the AMLAC is concerned, and in the exercise of its powers, there must be a procedure to be adopted, and that there must be an application before the court, and the court must have granted the application, and that is the exercise of the power, the valid. The grant of the power is constitutional,
Right,
but the procedure...
The Ombudsman, being an intelligent witness, may answer.
You must be referring to the freezing of assets.
No, I'm referring to the general exercise of the power of the AMLAC, Your Honor. My point is this: the AMLAC cannot just, in response to an inquiry, conduct an investigation, submit a report, and on the basis. That is my point.
If Your Honor, please, the point made by defense counsel is irrelevant. He earlier stated the proffer of testimony. And if you examine the request for subpoena, which they themselves submitted, they only offered two purposes for the subpoena of the Ombudsman. Number one, in order to prove that the Chief Justice Corona does not have foreign-denominated accounts amounting to $10 million. That's the first purpose. The second purpose is, and for them to explain why an investigation is being conducted on matters already within the jurisdiction of this Honorable Impeachment Court.
We have no quarrel.
The validity or invalidity of the actions of the Ombudsman with respect to the investigation being conducted over the Chief Justice, that's irrelevant here, Your Honor. In fact, those are legal conclusions which have no room in a trial.
We do not question the validity of the exercise of the power. We made that clear, Your Honor. But our point is, that power, although constitutional in character, excuse me, in character, must be exercised in accordance with the procedure laid down by jurisprudence and the law. That's our point.
Well, if you want to establish that, Mr. Defense Counsel,
sustains,
all that the Ombudsman had already stated that she sought the assistance of the AMLAC. How the AMLAC performed his function, I do not know whether the Ombudsman is competent to testify on that. And she has already answered the question. She sought the assistance of the AMLAC. How the AMLAC got records, that if there are records that he got and delivered to the Ombudsman, I don't know whether you can ask if the witness is competent to testify on that, if she knows how the AMLAC performed this function.
Well, I was just asking her whether the
We
record...
presume the regularity of official conduct.
Right, Your Honor. I fully agree with that. But as I have articulated, Your Honor, I have a point, and that is the validity of this alleged assistance made by the AMLAC without complying with the provisions of the law on the matter, Your Honor.
Appreciation of the evidence by this court. If there's any violation by the AMLAC, that's another issue altogether. He will answer for it. So please proceed.
Okay. Thank you, Your Honor. Now, going back to the complaints filed with your office, more particularly one by the Honorable Noli or Emmanuel Tio Santos, did you notice that practically the entirety of the allegations therein mentioned are merely based on your newspaper accounts?
Asking for opinion and conclusion, Your Honor, and it's irrelevant.
Why, I'm asking you.
If Your Honor, please, I
May I
do not...
answer?
Based on newspaper accounts?
Yeah.
Is that your conclusion?
No, did you notice that what she stated there is based on...
Under the assumption that I always read all newspaper accounts.
Now you... No, I have a definite question.
Yes.
I have gone over the affidavit
Yes.
of Noli
Yes.
Santos,
Yes.
Tio Santos.
Yes.
And I noticed that all that which was stated in there are practically coming from newspaper or newspaper accounts.
Yes.
And my question
you
to
noticed
all-
it. You noticed it.
Yes,
Yes,
and
sir.
my question to you is, did you notice that?
Well, he attached to his complaint newspaper clippings.
And you will agree with me that newspaper clippings had no probative value whatsoever, especially so in this particular case where the subject to be investigated is a Chief Justice of the Supreme Court.
Irrelevant, Your Honor. I cannot understand the line of questioning because it was a defense panel who themselves asked to subpoena the Ombudsman and to produce documents relating to the $10 million account. That is all. And we have already stipulated that the complaints do not mention the $10 million accounts.
Let the witness answer. She's a very intelligent witness.
Well, as I said, Your Honor, he attached to the complaint newspaper clippings. But let me emphasize that before I invoked the assistance of the AMLAC, I first asked the AMLAC, I first furnished copies of the complaints to the AMLAC, thinking that the charges might have had to do with matters within its jurisdiction. And then, when I wrote the AMLAC again, I only received yet the first complaint. In other words, the second and third complaints, including that of Mr. Santos, had not yet been within Ombudsman.
Thank you, Madam Ombudsman. I propounded that question, Your Honor, Madam Ombudsman, in the light of what appears in this request that you sent to the Chief Justice. May I read for the record, Your Honor?
Yes.
Well, you may only be removed from office through impeachment proceedings. This office, as reflected earlier, has the power and duty to investigate you for any serious misconduct in the office for purposes of filing a verified complaint for impeachment, if warranted.
Yes, Your
It
Honor.
was on this account that this office conducted an initial evaluation of the complaints. I'm led by that statement of yours that it was on the account made by the complainant appliance that you conducted the initial investigation of the complaints. Am I right?
Your Honor, on account
Thank you.
of the complaints.
Yes.
Yes.
But there is nothing in the complaint relative to what you wanted to be investigated, and that is the $10 million account.
Precisely, Your Honor. Again, I sound like a broken record. I said, furthermore, we received a report that the Chief Justice has $10 million. And that report was based on the report that was given to me by the AMLAC. And these are the documents given to me by the AMLAC.
You totally disregarded the affidavit complaints.
Not
of
disregarded.
Noli Santos.
Not disregarded.
In what sense or what value did you give to that complaint?
Well, there were 3 complaints in...
No, I'm sorry, Your Honor. I'm merely referring to Noli.
But why should you drop the other complainants?
No,
Because they have essentially almost the same complaints.
May I-
They were complaining against acquisition of unexplained wealth.
If Your Honor, please, I'm just asking a question. May we request most respectfully that the witness be admonished not to argue with the...
I'm not
This
arguing, I was just
representation.
explaining. Your Honor, I was just explaining.
Just a minute. The witness is explaining to the counsel that she did not see the 10 billion was obtained from a report to her by the AMLAC. She initially referred the complaint submitted to her by private parties, if I recollect her former statement, to the AMLAC, and there was a report returned by the AMLAC to her, and in that report was a statement about a 10 million account, $10 million account, supposedly of the respondent. Am I correct in this, Madam?
Yes, Your Honor.
All right, so that's the situation.
All right. The way I understood you...
Counsel, proceed.
Thank you, Your Honor. The way I understood you, you received that report from the AMLAC. Was it prior or after your letter of April